Thank you for joining us. My name is Samantha Jessner, and I am the presiding judge of the Superior Court of Los Angeles County. I am joined today by Assistant Presiding Judge Sergio Tapia and Executive Officer Clerk of Court David Slayton. This morning, I signed a general order requiring that Mr. Slayton direct court staff, when requested by the judicial officer presiding over the proceeding, and after the judicial officer has made specific findings, to operate electronic recording equipment in certain proceedings in family law, probate, and unlimited jurisdiction civil matters, so that litigants have access to the verbatim record they need to consider an appeal and appeal their cases. This general order addresses the constitutional crisis in courtrooms across our large and diverse county, a crisis that has left vulnerable litigants in family law, probate, and unlimited jurisdiction civil matters with no access to a verbatim record of their proceedings, essentially extinguishing their ability to seek meaningful appellate review. This constitutional crisis is the result of a worsening and well-documented court reporter shortage and arbitrary statutory restrictions on electronic recording. It directly impacts the court's ability to meet our mission of providing fair and equal access to justice to all we serve. Simply put, no record, no justice. It is this court's assertion that the lack of access to verbatim records presents serious equal protection and due process violations for litigants, an issue about which the judicial officers of this court have long expressed concern, and one that should not be countenanced by any public official who is dedicated to securing access to justice for the residents of Los Angeles County. 6 years ago, the California Supreme Court stated that the lack of a verbatim record will frequently be fatal to a litigant's ability to have an appeal decided on the merits. Put differently, no transcript, no appeal. To produce verbatim records, the court currently relies on court-employed court reporters, electronic recording, and privately employed court reporters who report proceedings at the litigant's expense. The law requires courts to provide a court reporter in felony, criminal, and juvenile cases. Conversely, the law allows electronic recording in limited civil, including evictions, misdemeanor criminal, and infraction cases. Almost 50 years ago, the legislature deemed electronic recording to be a reliable way to capture the verbatim record in these case types, and we have successfully used electronic recording for many years. As a result, we know a reliable and accurate transcript is produced from the recording. In fact, our appellate division relied on transcripts created from electronic recording for appellate review without incident more than 500 times last year. But for litigants in family law, probate, and unlimited civil cases where electronic recording is not allowed and a court reporter is not required, the court does not have enough court-employed court reporters due to the statewide and nationwide shortage. What this means is litigants have the following choices for obtaining a verbatim record, all of which are far from ideal. Their options are: they can try to retain a private court reporter if they can find one who is available, which is challenging, And if they can pay thousands of dollars per day for that private court reporter, or one or both parties may ask the court to delay the proceedings until the court can provide a court reporter at no cost to the parties. As a result of the shortage, this can take weeks or months. As you can imagine, delay is often not an option in these cases, especially in domestic violence, conservatorship, and child custody cases, to name a few examples. Or they can proceed without a transcript, without a record, without a fighting chance on appeal. In short, litigants in these courtrooms must pay, delay, or walk away. Each one of these options restricts the litigant's constitutional right to equal and timely access to justice, as well as due process. In reality, this means parties in matters where there is a smaller sum of money in dispute, as is the case in limited jurisdiction civil cases, for example, they are provided full appellate rights because the law allows their matter to be electronically recorded. On the other hand, a woman seeking a restraining order against an abusive husband has no access to the same appellate rights because the law does not allow her hearing to be electronically recorded when the court cannot staff the courtroom with a reporter. The same is true for a father who lost custody of his child in court, and for an elderly person facing a limitation on their liberty and independence by way of a conservatorship, or a person facing a jail sentence after being found in contempt. This disparity is indefensible, contrary to due process and equal access to justice, and unconstitutional. This is why this court is taking a significant step to equip judicial officers with a constitutional safety net to provide litigants with a verbatim record of the proceedings when a court-employed court reporter is unavailable and fundamental rights protected by the constitutions of California and the United States are at stake. The court reporter shortage is real, it's growing, and it is without an end in sight. Any assertions to the contrary are without a basis in fact. This state of affairs cannot continue while we wait for a fix that frankly is not coming. Our court has spent almost $14 million provided by the governor and the legislature to recruit and retain court reporters. This includes a $50,000 signing bonus, $15,000 for student loans and an equipment allowance, $25,000 in finder's fees, $10,000 per year in retention bonuses, and a significant advertising campaign that includes advertisements on billboards and bus stations across Los Angeles County. Earlier this year, we agreed to increase court reporter salaries over the next 2 years by 10%. Also, in an effort to increase the pipeline to a court reporting career, the court started its own internal court reporting training program, offering current court employees the opportunity to become a court reporter with on-the-job training during work hours, free of charge. And we will continue to invest in efforts to do everything we can to expand the number of court-employed court reporters. Yet, despite the court's dedicated and strategic efforts and significant expense to the taxpayer, the court has recorded a net loss of 117 court reporters since 2018, bringing our current number of vacancies to 125. Even with the robust incentives the court has been offering, We have a net loss of 11 court reporters since January of 2023. In other words, our hiring efforts have not kept pace with retirements, and even more concerning is this. Over 70% of our current court reporter workforce is eligible to retire today. This combination of factors has resulted in an unacceptable reality. Since January of last year, this court has held 525,000 legal proceedings where no verbatim record was made. Assuming there were at least two parties in each case, that's at least 1 million Angelenos deprived of their full appellate rights for legally unsupportable reasons. This court has made a concerted effort over the past several years to impress upon lawmakers the dire nature of this crisis. Alongside members of the public, legal services organizations, the Judicial Council of California, members of the legal community, and bar associations, we engaged with the Assembly and Senate in one-on-one sessions and in large groups, educating them and imploring them to support a workable legislative solution to the constitutional crisis. As has been the case for the past many decades when efforts have been made to address this crisis, another legislative session came to a close last Saturday without any meaningful action to address this chronic constitutional crisis. Something must be done to ensure due process for all litigants across Los Angeles County who come to court seeking equal treatment under the law and seeking justice. Some argue that we should wait and let others resolve this crisis. Some argue that help is on the way in the form of more court reporters who are currently in school. Some argue there are plenty of court reporters to be hired. To date, none of these assertions has proven to be based on fact. As a result, we cannot stand by and do nothing and allow over 1,500 proceedings to go forward each day and to continue without access to a verbatim record. Which leads me to the court's actions today. This morning, in my capacity as the leader of the largest consolidated trial court in the nation, I have issued a general order permitting judicial officers in family law, probate, and unlimited civil cases in which fundamental rights are at stake and a court reporter is unavailable to use electronic recording in order to provide litigants access to a verbatim record of the proceeding. Specifically, in order to use the electronic recording equipment, a judicial officer may make the following findings. 1, the proceeding concerns matters that implicate fundamental rights or liberty interests, such as child custody and divorce proceedings and the right to self-determination in conservatorship proceedings. 2, one or more parties wishes to have the possibility of creating a verbatim transcript of the proceedings. 3, no official court-employed court reporter is reasonably available to report the proceeding. 4, the requesting party has been unable to secure the presence of a private court reporter to report the proceeding because a court reporter was not reasonably available or the party could not afford a private court reporter. 5, the proceeding involves significant legal and/or factual issues such that a verbatim record is likely necessary to create a record of sufficient completeness. And finally, the proceeding should not, in the interests of justice, be further delayed. The general order does not impose an obligation or requirement for judicial officers to enable electronic recording. Each judicial officer will exercise their discretion in determining whether to use electronic recording to capture the record. Electronic recording supplements rather than replaces court-employed reporters for cases lacking a verbatim record. I want to state unequivocally that the court has no intention of laying off or reducing the court's court reporter workforce. The actions undertaken today are simply intended to address what is clearly a constitutional crisis and provide a mechanism for this court to establish a constitutional safety net to uphold the equal protection and due process clauses of the California and United States constitutions. Oftentimes in our history, courts have been called upon to address wrongs. Today is one of those days. While this constitutional crisis is not limited to Los Angeles, as the largest consolidated trial court in the state and the nation, our court sees the largest impact on individual litigants who, without the action taken today, will continue to see their constitutional rights denied. Today, we embark upon a new path to provide a constitutional safety net, one that employs the use of whatever available resource we have to ensure that litigants leave our courthouses with a verbatim record of what transpired inside, and with a meaningful opportunity to appeal their matter. I am now happy to take your questions.
For the reporters on the line, if you have a question, please raise your virtual hand. We will call on you one by one. Kevin Rector from the LA Times. You may unmute yourself and ask your question.
Hi there, thanks. I appreciate it. Are you flaunting the law here? Are you deciding to issue policy that is contrary to the law? And if so, do you expect there to be litigation, and how much do you think that will cost the county in the long run? Essentially, what do you make of the fight to come?
I think when you read the general order and you read the legal analysis as well as the factual basis, you will agree with us, which is the actions today are very much supported by the law and the facts.
As a follow-up, I understand your position is that this is within the law. There is a law precluding this type of recording in these types of proceedings. There is also, the California Supreme Court ruling that you mentioned. Is your position that there is a contradiction in California law and that you are in line with one side of that contradiction, even if there is another side? Or is it your position that it is not the law in California that these recordings are precluded?
It's our position that there is a contradiction in that the law treats some litigants, affords to some litigants the right to have their proceeding electronic recording, but for no reason that's distinguishable or obvious in the law, it treats other litigants differently, meaning that those litigants are not allowed to have electronic recording in those types of proceedings. And that constitutes an equal protection violation.
Thank you, Kevin. Do we have any more questions? Maya from Bloomberg News. Go ahead and unmute yourself and ask your question.
Has the court, when considering this action, discussed with the court reporters union or staff? Can you share what those conversations have been like?
I'm going to let Mr. Slayton answer that question.
Thank you, Maya. This is David Slayton, the Executive Officer and Clerk of Court. We've been working with our labor partners for years on this issue. We've been working collaboratively with them to bring in additional court reporters. We've talked to them extensively about the crisis that we've described today, and we continue those conversations with them. We're hopeful that they will be supportive of the efforts that we've taken today to make sure that individuals who come into court have a constitutional safety net to make sure that they leave with a verbatim record. And as Judge Jessner pointed out, this would only be done when there is not a court-employed court reporter available, or even a privately hired court reporter available. So it would only be used in situations where there's not a court reporter available. So we'll continue to work with our labor partners to ensure that their interests are considered, as we've done over the last several years.
Thank you, Maya. We will now go to Cheryl Miller. Cheryl, you're okay to unmute yourself and ask your question.
Hi, I'd like to know if you consulted with the Chief Justice on this before issuing the order.
We have had several conversations with the Judicial Council of California.
And did the Chief Justice offer her support for what you're doing?
As I said, we've consulted and had many discussions with the Judicial Council.
Thank you, Cheryl. We will now move on to Michael Monks. Michael, go ahead and unmute yourself and ask your question.
Thank you for taking my question. If your actions, as you say, are supported by the law and the facts, what is different about today compared to the years leading up to this? As you've watched this crisis mount, why not take the action sooner?
Well, one thing that's different about today is today we have fewer court reporters than we had a week ago and a month ago and a year ago, etc. Up until about November of 2022, we were able to provide court reporters in the courtrooms across the county. That's no longer the case.
Can I add something?
Yeah, Dave, go ahead.
I want to add one more thing to that, which is that, as Judge Jessner said, over 1,500 proceedings are happening every single day right now. Today, 1,571 proceedings on average will occur where there will be no access to a verbatim record. We've been working with the legislature over the past year and a half throughout their full session of 23 and 24 to come up with a solution. And as you all are likely aware, and as Judge Jessner pointed out, the legislature took its final recess before adjournment starting on Saturday. And so there is no legislative action that's available to address this issue. And so that constitutes for us an emergency and a crisis, which is why the court's taking the action it needs to do today, because at the earliest, the legislature would come back into session in December to address the issue, which means between now and December, that 1,571 proceedings per day would occur every day between now and then. And so those constitutional rights that Judge Jessner has described would continue to be violated every day. So really, time was of the essence.
Thank you, Michael. We will now go to Skylar Romero with the Daily Journal. Skylar, go ahead and unmute yourself and ask your question.
Hi. Thank you for taking my question. Apologies if this has been covered already. Is this going to have any effect on the press or the public's ability to record proceedings?
Thanks very much, Skylar. As you know, the court has a general order that's already in existence and local rules that deal with recording, and there's also California's rules of court. Those are not impacted by today's ruling. This is really in capturing the verbatim record, which of course the press has not been doing. What they're capturing by filming or other means is covered by different orders and rules.
Thank you, Skylar. We're going to go back to Kevin Rector from the LA Times. Kevin, go ahead and unmute yourself and ask your question.
Was there any effort on your part to make this announcement a collaborative one or a coalition one amongst various counties, or was there any talk with leaders from other court systems about doing this as a collective?
This subject is often discussed among leaders in other counties throughout the 58 counties in California. Because of the size of our court and the number of people that we serve, as I said during my prepared remarks, We are so greatly impacted by this that it was time for the Los Angeles Superior Court, as the largest court in the state and the nation, to address this crisis, and this is how we've chosen to do it.
Thank you, Kevin. Seeing no more questions, that concludes our conference. Thank you very much for joining us this morning.